Good day, ma'am. I am Jovel Sagusay from BCHM 3B, and this is my chapter 13 entitled Labor Law. So before we proceed to the report, here's are the list of the learning objectives. So first one is to enumerate the classification of employees, their benefits, privileges, and policies affecting them. Second is to identify some best practices in handling human resources in tourism establishments. Third is to identify the procedures in handling sexual harassment in the workplace. And lastly is to explain the rights of workers employed in tourism establishment. Next is the topic outline. So the first one is the constitutional provision on labor. Second is types of employees. Third is benefits, privileges, policies affecting employees. Fourth is the union rights, strikes, and lookouts. And lastly, the laws against discriminations. So, the tourism industry, with its labor-intensive nature, is prone of many labor issues. Hence, a labor laws plays a vital roles in the efficient operation of the various business enterprises related to tourism. These chapters deals with important provision governing labor laws as the benefits, privileges, and policies affecting employees well. So, the first one is the constitutional provision on labor. So, under the section 3, the state shall afford full protection to labor, local and overseas, organized and unorganized, and promote full employees and equity of employment opportunities for all. So, it shall guarantee the rights of all workers to self-organization, collective to bargaining, the negotiation, and peaceful concerted activities, including the rights to strike in accordance with law. They shall be entitled to security of torture, and human's condition of work and living wage. So, they shall also participated in policies and decision-making processes affecting their rights and benefits as may be provided by law. So, the state shall promote the principle of shared responsibility between workers and employers and the preferential use of voluntary modes in settling disputes, including conciliation, and shall enforce their manual compliance therewith to foster industrial peace. So, the state shall regulate relations between workers and employers, recognizing the rights of labor to its just share in the fruit of production and the rights of enterprises to a reasonable return of investment and to expansion and growth. So, in other section 14, it says that the state shall protect working women by providing safe and healthful working conditions, taking into account their maternal functions, such as facilities and opportunities that will enhance their welfare and enable them to realize their full potential in service of the nation. Next is under the section 15. This says that the state shall respect the rule of independent people's organization to enable the people to pursue and protect within the democratic framework their legitimate and collective interest and aspiration through peaceful and lawful means. Under the section 16, it says that the right of the people and their organization to effectively and reasonably participate at all levels of social, political, economic decision-making shall not be abridged. So, the state shall by law facilitate the establishment of adequate conciliation mechanism. So, in discussion of the law, the labor whether local or overseas, organized or not organized, shall be given constitutional protection. So the right to strike, although already a part of the right to self-organization, is especially mentioned. The right of living wage is expressly stated. So a living wage, it is the adequate to sustain the worker and his family and dignity. So the first is the casual employees. So casual employees are those whose employment in neither regular, project, or non-seasonal and defending under the Article 280 of the Labor Code. There is a casual employment where the employee is engaged to perform a job, work, or service which is merely incidental to a business of the employer, and such job work, or service in for a definite period made unknown to employee and time to engagement, provided and any employees of has rendered at least 1 year of service, whether such a service is continuous or not, shall be considered a regular employee with respect to activity in which he is employed, and his employment shall continue while such activity exists. Next one is the seasonal employees. So, seasonal employees are those whose work on service are seasonal in nature and the employment is for the duration of the seasons. Regular seasonal employees are those called to work from time to time. The nature of their relationship with the employer is such that during the off-season, they are temporarily off, but during the summer season, such as re-employed or when their service may be needed. So they are not strictly speaking separated from the service but are merely considered as on leave or absence without pay until the re-employed. Their employment relationship is never severe but only suspended. As such, those employees can be considered as in a regular employment or the employer. It affects these seasonal regular employees enjoy security of tenure and cannot be dismissed without just cause. Next is the project employees. So, a project employees is one of whose employment has been fixed for a specific project or undertaking, the completion of termination of which has been determined and the time of engagement of employees of where the work is service to be performed in seasonal in nature, and the employment is for the duration of the season. So the principal test of determining whether an employee is a project employee or a regular employee is whether the project employee was assigned to carry out of the specific project or undertaking the duration and scope of which were specified at the time an employee was engaged for the project. Failure of the employer to file termination report after every project completion with the nearest public employment office is an indication that an employee was not a project employee. So next is the probationary employees. So a probationary employees is one who is on trial by an employer, during which is the employer determines whether or not he is qualified for the permanent employment. Probationary employment shall not exceed 6 months from the date the employee started working, and in all cases of probationary employment, the employer shall make known to the employee the standard under which he will qualify as the regular employee of time of his engagement. Where no standards are made known to employee at the time, and he shall be deemed to a regular employee. Next is the employees for a fixed term. So these are employees covered in employment contract providing a term employment or fixed period employment. Stipulation providing for a fixed period employment are valid when the period agreed upon has been knowingly and voluntarily agreed by the parties without force, duress, or improper pressure exceeding on the employees, and when such stipulation were not designed to circumvent a law, the security of tenure. Next is the overseas Filipino worker or OFW. So OFW refer as a migrant worker. So overseas Filipino worker refers to a person who is engaged or has been engaged on the remunerated activity in the state of which he or she is not legal resident. So a person to be engaged in a remunerated activity refer to applicant worker who has been promised or assured employment overseas and acting on such promise or assurance sustain damages and or injury. So the law which govern overseas employment is Republic Act 8042 or the Migrant Worker and Overseas Filipino Act of 1995. Special worker. So first one is the apprentice. So an apprentice is a worker who is covered by written apprenticeship agreement with an individual employer of any of the recognized entities. It is a person undergoing training for the approved of apprentice occupation during the established period assured by an apprenticeship agreement. So, an apprenticeship agreement is an employment contract wherein the employee bind himself to train the apprentice and the apprentice is turn accept and term of training. An appreciable occupation means any trade for an employment of occupation which required more than 3 months of practical training on the job supplemented by related theoretical instruction. The period of apprentice shall be exceed of 6 months. Next is the learners. So, learners are person hired as trainees in semi-skilled and other industrial occupation which are non-apprenticeable and which may be learned through practical training on the job in a relatively short period of time which shall not exceed 3 months. Learners may be employed when no experienced workers are available. The employment of learner is necessary to prevent curtailment of employment opportunities, and the employment does not create unfair competition in terms of labor costs of impair or lower working standard. Next is the handicapped workers. So, handicapped workers are those whose earning capacity is impaired by age of physical or mental deficiency or injury. Under the Section 4 of Republic Act 7277, also known as the Magna Carta for Disabled Persons. Or disabled person are those suffering from the restriction of lack of different abilities as result of the mental, physical, or sensory impairment to perform an activity in manner or within the range considered normal for the human being. A qualified disabled employee such shall be subject in the same term of condition of employment and the same compensation, privileges, benefits, fringe benefits, incentives, or allowances as a qualified able-bodied person. Next is the benefits, privileges, policies affecting employees. So the first one is the minimum wage. So by the virtue of Republic Act number 6727 or the Wage Rationalization Act, the determination of the minimum wage rate are now within the function of the Regional Tripartite and Productivity Board. So the concept of minimum wage means more than setting of floor wage to upgrade existing wages. A minimum wage is underline the effort of the state to promote productivity, improvement, and gain sharing measure to ensure a decent standard of living for the worker and their families to affirm labor or primary social economic force. Next is the Labor Management Council. So, under the Article 255 of the Labor Code, it reserves the rights of an individual employees or group of employees, unauthorized or non-authorized, to prevent grievances to their employers at any time, with or without collective bargaining, with or without exclusive bargaining representative. The Department of Labor or Employment promotes the formation of Labor Management Council or LMC is organized and unorganized establishment. So an LMC, either as a council or committee, can serve as a forum where management or employees may air their concern short of collective bargaining. It is largely a communication mechanism which includes prevention of resolution or disputes. Harnessed to fullest and given the sincerity, confidence, and maturity of both sides, LMC can effectively secure the industrial peace provided it maintains its integrity. In fact, an LMC can be so effective it can make a labor union unnecessary. Labor Management Council requirements that employee representatives should be elected by the employees, not handpicked up by management. Next is the maternity and paternity leaves. So, first one is the maternity leave. Benefits are covered under the Republic Act number 8282 on May 1, 1997, or also known as the Social Security Act of 1997. So, under the said law, a female member or need not be married who has paid at least 3 monthly contribution in the 12 months period immediately preceding the semester of childbirth of miscarriage shall be paid a daily maternity benefits equivalent to 100% of her average daily salary credit for 60 days or 70 days in case of cesarean delivery. On the other hand, in Republic Act number 8187, also known as the Paternity Leaves Act of 1998, governed the granting of paternity leave benefits to every married male employee. Under the said law, every married male employee is in the private or public sector shall be entitled to paternity leave of 7 days with full payment for the first for the deliveries of the legitimate spouse with whom he is cohabiting. So the following conditions must be met in order to avail the paternity leave benefits. So first is the union right, strikes, and lookouts. So a legitimate labor organization or LLO has the requisite personality to suit on behalf of its member for their individual money claims. For the purpose of collective bargaining, a legitimate labor union must be certified as an exclusive bargaining agent who won the certification election. Strike. So strike means temporary stoppage of work by the concerted action of employees as a result of the labor or industrial dispute. Then lockout means temporary refusal of an employer to finish work as the result of industrial or labor dispute. So a labor dispute includes any controversy of matter concerning terms of condition and employments or the assertion of representation of person in negotiating, fixing, maintaining, charging, or arranging the terms and condition of employments, regardless of whether the disputant stands for the proximate relaxation of employee and employees. Next is the service charge. The service charges is the rule of applies only to establishment collecting services charged as hotels, restaurants, lodging houses, nightclubs, cocktail lodge, massage clinics, bars, casinos, gambling houses, and similar enterprises, including those entities operating primarily as a private subsidiaries of the government. So all service charges collected by the hotels, restaurant, and other similar establishments shall be distributed at the rate of 85% for all the coverage employees and 15% for management. So the share of employees shall be equally distributed among them. So the 50% shall be for the disposition by the management to answer for losses and breakage of this distribution to managerial employees at the discretion of the management in the latter case. Next is the employment contract. So, an employment contract is the virtue of which one person, employee, bind himself with respect to another to place at the service of the latter his own effort is in work, and the latter in turn agrees to pay him a compensation proportional to the time or the quantity of work done. So, a concept of employment contract is regulated under the provision of the Labor Code of the Philippines, Civil Code of the Philippines, and other special laws. Execution of employment contract are in the line with the characteristic of autonomy and contract wherein parties are free to stipulate terms and provision in the contracts as long as their terms or provision are not contrary to law, morals, or good customs, public or public policies. So the employment contract is impressed with the public interest. Next is the death benefits. So under the Social Security law, upon the death of the member who has paid at least 36 monthly contribution prior to the semester of death, his primary beneficiary shall be entitled to the monthly pension, provided that he has no primary beneficiary. His secondary beneficiary shall be entitled to a lump sum benefits equivalent to 36 times of monthly pension. If he has not paid the requirements 36 monthly contribution, his primary and secondary beneficiary shall be entitled to lump sum benefits equivalent to the monthly pension times the number of monthly contribution paid. The 555 or 555 or 12 times the monthly pension, whichever is higher. So a funeral grants equivalent of 12,000 shall be paid in cash or in a kind to help defray and cost of funeral expenses upon the death of member, including permanently total disabled member or retiree. So in case of work-related deaths, beneficiaries will receive death benefits under the Employment Compensation and State Insurance Funds. In addition to the beneficiary under the SSS law, accordingly, the amount of under the Employees Compensation Fund shall be an amount of equivalent to his monthly benefit, plus 10% thereof for the each dependent child, but not exceeding 5. The Employees Compensation Commission has increased the funeral benefits up to 10,000 pesos. Next is the health benefits. So this includes sickness, medical, and hospitalization benefits. Under the Social Security law, of member who has paid at least 3 monthly contribution in the 12 months period immediately preceding the semester of sickness or injury and is confined from 3 days in hospital, as well with the approval of SSS, shall be paid of daily sickness benefits equivalent to 90% of his average daily salary credit. In case of work-related sickness, the covered employee will be entitled to medical services, appliances, and supplies in addition to benefits under the SSS law. Next is the drug testing. So under the Republic Act number 9165 on June 7, 2002, also known as the Comprehensive Dangerous Drug Act of 2002, drug testing shall be done by the government forensic laboratories or by any of the drug testing laboratories accredited and monitored by the Department of Health or DOH to safeguard the quality of test result. Drug test certificate issued by accredited drug testing center shall be valid for 1 year period from date of issue, which may be used of other purposes. So in this regard, employers are mandated to provide company work rules and regulation under random drug testing from purposes of reducing the risk in his workplace. Accordingly, officers and employees shall be subjected to undergo the random drug testing. Any officer or employee found positive for use of dangerous drug shall be dealt with administratively, which shall be ground for a suspension of termination, subject of the provision of the Article 282 of the Labor Code. Next is the retirement. So under the Article 287 of the Labor Code as amended by the Republic Act number 7641, also known as the New Retirement Law, any employee may be retired upon reaching the retirement age establishment in the collective bargaining agreement or other applicable employment contract. In the absence of the retirement plan or agreement providing for retirement benefits of employee is establishment, an employee upon reaching the age of 60 years or more but not beyond 60 years, which is hereby declared the compulsory retirement age, who has served at least 5 years in the said establishment, may retire. The child entitled to retirement may equivalent to at least 3.5 months salary for every year of service, and fraction of the 6 months being considered as one whole year. Next is the uniform facilities or the policies rather. So some tourism establishment, which include but not limited to restaurant, department stores, rest area and gasoline station, deluxe and first class hotels, tourist inns, special interest resorts, apartels, motels, and those engaged in water transportation services requires their employees and staff to be well groomed and should wear clean and smart uniforms. Uniform policies in this establishment are prerequisite requirements in order to be accredited by the Department of Tourism. Next is the SSS, PhilHealth, Employment Compensation Commission, and Pag-ibig. So employees is the private sector are covered under the SSS law, wherein the mission is to promote the perfect and sound of variable tax-exempt social security system sustainable to the needs of the people, which shall provide meaningful protection of members and their beneficiaries against hazard or disability, sickness, maternity, old age, death, and other contingency resulting to the loss of income or financial burden. Next is the PhilHealth. PhilHealth assume the responsibility of administering the former Medicare program to private sector employees, with it landmark transfer from the Special Security System in April 1998. With the transfer come to turnover of the health insurance funds, initially totaling of 14 billion from the SSS, the amount of covered employee and the employer's shares in the medical care program. Next is the laws against discrimination. So, and under the Article 3 Declaration of the Basic Policy, so the state shall afford protection to labor, promote full employment, ensure equal work opportunities regardless of sex, race, or creed, and regulate the relation between workers and employers. So the state shall assure the rights of workers to self-organization, collective bargaining, security of tenure, and just human conditions of work. Next is the employment of women. So it is the policy of the state to protect the working women by providing safe and healthful working condition, taking into account their maternal function and such facilities and opportunities that will enhance their welfare and enable them to realize their full potential in the service of the nation. Next is the Labor Code of the Philippines provides protection for the working women. Consequently, first is no woman regardless of age shall be employed or permitted to work in any commercial undertaking between midnight at 6 o'clock in the morning and the following days, except in the cases where the woman employees has been engaged to provide health and welfare services of when the nature and the work requires a dexterity of women. Next is the sexual harassment in the workplace. So under the Republic Act number 7877, also known as the Sexual Harassment Act of 1995, sexual harassment is committed by an employer, employee, manager, supervisor, agent, or employee, manager, supervisor, agent of the employee, or any other person who having authority, influence, or moral ascendancy over another in the work environment, demands, requests, or otherwise requires any sexual favor from others, regardless of whether the demands, requests for requirements for submission in accept or not. Next, in a work-related environment of sexual harassment and committed when. So the first one is the sexual favor is made as a condition in the hiring or in the employment or re-employment or continue employment of said individual, or in a granting said individual favorable compensation, term, condition, promotion, and privileges, or the refusal of grant of sexual favor result to limiting, segregating, or classifying the employee which is in any would discriminate, deprive, and diminish employment opportunities or otherwise adversely affect said employees. Next is the best labor practices and tourism establishment. So this topic has been added to enable the reader to appreciate the best labor practices of selected tourism establishment from the lodging industry, travel agency, tour operator, transportation companies, food service industry, and tourist sites. It will be noted that 90% of the selected respondents agree that it is imperative to have a proactive and supportive human resources department, which will be instrumental in enhancing the welfare of the employee and helping the company toward the growth in investment. So an open door policy with the president of the general manager of the company is most welcome, as it has proven to be the most effective means of removing barriers and communication and enhancing a shared responsibility of nationalhood between capital and labor. So before we end our report, according to Abraham Maslow, a motivated worker will be a productive worker. And that's all about my chapter 13. Thank you.